Good afternoon. Welcome to our presentation today. Today we're going to be talking about the No Surprise Billing Rules, Part 2, the recent regulations that just came out. I'm going to be focusing today on what the providers need to know. There are sections of the new rules that apply to payers, but since most of my work is done with providers, I'm going to be focusing on the provider side of things. There, I send out some information on how you can contact Charles in order to get that link. But the materials we provided you for Part 1 includes the new rules themselves, including the commentary, the regulations, and also the CMS fact sheet or the HHS fact sheet. For Part 2, we've also given you a copy of the rules and the commentary along with the HHS commentary. You can access those at the links provided there in the slides too. In addition, we've also provided to you copies of the relevant forms that have been published by the agency, including for Part 1, the model notice of patient protections against surprise billing and the model notice and consent to balance bill the patients. We talked about that a while ago. Otherwise, for Part 2, we provided you with the forms for the model notice concerning the right to receive the good faith estimate, the good faith estimate template, separate document that talks about the data elements for the template, the SDR determination notice to the parties, and the payment settlement form. Additional resources along with all of those resources are available at the new website that the government has put up to help with the surprise billing. So if you want to access any of those resources or look for additional resources as they come out, you can go to this website and that should give you a lot of help. All right, let's back up then and let's talk about surprise medical bills. It's helpful to understand what the purpose of these rules is. Why were they put in place? Well, the government was concerned about surprise medical bills, specifically situations where an uninsured or self-pay patient receives an unexpected medical bill that they had no idea was going to be as much as it was. The government was also concerned about situations involving insured patients who receive unexpected medical bills from out-of-network facilities or providers. In this context, it especially arises in situations where that insured patient receives care from either an out-of-network facility or out-of-network provider for certain emergency services. For example, they may suddenly realize that the payer limits the coverage for emergency services, or it requires pre-authorization, or they otherwise don't have coverage or the coverage that they thought that they had for these emergency services, and suddenly they get hit with a big bill. Or alternatively, it might also arise in a situation where they receive a bill from an out-of-network provider who was rendering the services at a network facility. So the patient shows up at a facility, a hospital or other facility that they thought was going to be covered, only to be surprised by receiving a separate bill from surgeons, anesthesiologists, radiology, pathology, or any of those other services who may be out of network. So in order to address those situations, the government came up with these no surprise billing rules. They become effective January 1st, 2022. Quite frankly, I'm surprised that the government has put such a short lead time on that, especially for the new rules that just came out on September 30th, dealing with self-pay patients. But these new rules apply in those two situations that we just talked about. They provide protections for insured patients and also for self-pay or uninsured patients. For the insured patients, they limit the amount that an out-of-network provider or facility may bill the patient and the payer for certain emergency services that are provided at emergency facilities defined in the regulations. We'll talk briefly about that. In addition, they apply to non-emergency services that are provided by an out-of-network provider in an in-network facility. They also apply to air ambulance services, but I'm actually not going to get into the air ambulance services too much in this program, just because most of my clients are not air ambulance services. So in addition to placing those limits on the amount that these out-of-network providers can charge, they also require the providers to give the patient a notice of rights to the patient. Now, those were issues that came out as part of the Part 1 rule that issued in last July. The Part 2 rule that just issued on September 30th goes on to include, when it comes to those insured patients, the independent dispute resolution process for handling those disputes between the out-of-network provider and the payer to determine how much that out-of-network provider is going to get paid. So those are the protections for insured patients. For self-pay patients, the new rules that just issued in September, Part 2, provide additional protections. They require providers and facilities to give the patient, a self-pay patient, a good faith estimate of the charges that they're going to receive for the services. In addition, if those services come back, the actual bill is substantially in excess of that good faith estimate, then the government's established a selected dispute resolution process in order to determine the amount that the self-pay patient should pay. In addition, it requires the providers and facilities to give the patient a notice of those rights. Well, what happens if you violate the rules? Well, under the Act, the No Surprises Act, the actual statute, you can get it up with a $10,000 civil penalty. The government issued a proposed rule in early September dealing with some of those requirements, but the exact scope of those are still a bit unclear. We have not got the final rule yet. We do have the proposed rule. We'll have to watch for the final rule to see exactly how that shakes out. In addition to that potential penalty, you can also have your payment limited or denied pursuant to the regulations, like we'll talk about in a little bit. Now, Part 1, this part dealing with the limits on the amount that an out-of-network provider can charge for emergency services or certain non-emergency services, we actually covered in a webinar on August 19th. So I'm not going to get into that. Instead, I'm going to talk about the new rules that came out in September dealing with that independent dispute resolution process, as well as the obligations for self-pay patients. So I'll cover those items and also hopefully wrap up with a few suggestions of some of the things that you need to do by January 1st, 2022. So let's talk first about that IDR process. Let's make sure you understand the scope of this. This new IDR process, of course, is only going to apply to situations where emergency services are furnished by an out-of-network provider or an out-of-network facility at an emergency service or an emergency facility. It's not all emergency services that are being provided. It's not all providers. It's only these situations. So it applies to an emergency service furnished by an out-of-network provider or an out-of-network facility at an emergency facility. For purposes of that portion of the rule, a facility is relatively narrow. It is an emergency department of a hospital or independent freestanding emergency department that's licensed by the state, and it probably includes urgent care centers. Okay. This rule concerning the IDR, this payer and provider dispute process, also applies to non-emergency items or services that are furnished by an out-of-network provider at an in-network facility. For purposes of this portion of the rule, a facility is defined as a hospital, hospital outpatient department, critical access hospital, or ASC, that has a contract with a health plan covering the services provided, including single case agreements. So let's put this in context. The rules I'm going to talk about now about this dispute process, it only applies in those limited contexts of out-of-network providers in those limited circumstances. It does not apply in all out-of-network situations. It only applies in those limited circumstances. So if you happen to fit within those limited circumstances under the no surprise billing rule, the total amount that the out-of-network pay or the payer has to pay the out-of-network provider or facility is determined by the following issues, okay? First, you would look to see whether or not there's an amount determined by an applicable all-payer model agreement under the Social Security Administration for your particular area. Most entities aren't covered by that. So then you would look to see whether or not there's an applicable all-payer model agreement amount determined by state law. Most states don't have that. So for most of us, we're dealing with the next two items, and that's what we're going to be focused on today. If neither of those foregoing issues apply, then you would look to the amount agreed upon by the payer and provider facility during their 30-day open negotiation period. And if the parties can't come to terms during that 30-day open negotiation period, then the plan or the provider can go ahead and submit that to this independent dispute resolution process. And that will determine the amount that that out-of-network provider is going to be paid. So to initiate that open negotiation period for the initial negotiation, Within 30 days after the out-of-network provider or facility receives either the initial payment or the notice of denial sent from the payer, then the provider can go ahead, the provider or facility can go ahead and initiate the 30-day open negotiation period by sending a notice to the other party, the payer in this case, using the HHS form. The government has a form that you can submit. They have to submit that either by paper or you can submit it by email if you have a good faith belief that the other party will receive it and the other party has the right to have it printed out. So most of the time you're going to be able to communicate with the payers electronically because you've been communicating with them concerning the denial of payment, presumably. That notice that you submit to trigger that open negotiation period has to contain certain elements, including the items and services furnished, the date of the items or services were furnished, the service code, initial payment amount, if applicable, the offer of the out-of-network rate that you are willing to accept, and contact information of the person who sent in the open negotiation notice. So you start that 30-day period so the parties can negotiate by sending that notice. That notice lasts for the 30-day period beginning on the date that you send that notice out. If the parties, the government has actually issued a form that will help you start that negotiation period. You can access that at that website that I sent to you or the link there on the slides. If the parties cannot agree on the out-of-network rate during that 30-day open negotiation period, then either party may request a resolution through the independent dispute resolution process. In order to initiate that IDR, you have to wait until that 30-day open negotiation period ends. So you can't submit it. Even if you've reached an impasse during it, you've got to wait till the end of that 30-day period. So it would be 31 days after the payments received or the notice of denial is received from the payer. So within 4 business days after that 30-day period ends, then you can go ahead and submit a written notice requesting the IDR using the HHS form. And you have to submit that written notice to both the other party, and you submit that to the other party either by paper or presumably by email. And you've got to submit it to HHS using the federal IDR portal. The government is setting up this IDR process, including lining up the IDR entities and getting the portal in place. You cannot initiate that IDR process if the out-of-network provider has already obtained consent to balance bill the patient or the rules that we talked about last time, the Part 1 rules. But that's going to be a relatively very limited situation where that occurs. That notice of initiation, when you are initiating that IDR process, has to contain certain elements, including the specific items that are under dispute. Again, it would only be emergency services that are provided by an out-of-network provider, out-of-network facility, or services by an out-of-network provider at an in-network facility. It's got to contain the names and contact information of the parties, state where the item service was furnished, the date the open negotiation period began, the preferred certified IDR entity, attest that the items or services are qualified for IDR, and you've got to include the qualifying payment amount, the QPA. This QPA is all important when it comes to the dispute resolution process. The QPA is the plan's median contracted rate in 2019 for the same or similar items or services provided by a similar provider in the same geographic region as adjusted by the Consumer Price Index going forward. This QPA is very important because it's going to be the primary driver of what the payer is going to be required to pay. As part of the information under Part 1 of the rule, the insurer, the payer, has to give to the provider its QPA as part of its denial or when it responds to the payment information. So presumably the provider will have that information. In addition, you've got to provide certain general information about the IDR process as specified by HHS in its form. And again, the government has issued the form that you need in order to initiate that IDR process. You can access it there at the website that I've identified on your paper or that general website I mentioned earlier. All right, so once you send in that IDR notice, then within 3 days after the IDR is initiated, the parties may agree or object to the IDR entity. They may object if, for example, an IDR entity has conflict of interest or otherwise it does not satisfy the qualifications set forth in the regulations. So they've got 3 days to try to identify who the IDR entity is going to be and agree to it, or if they don't agree, then then within 4 days or 1 day later, the initiating party has to notify HHS of the IDR entity if the parties agree. In addition, within 4 days after that IDR is initiated, if for some reason you did not initiate the IDR, but you think it's inappropriate for the IDR, for example, maybe the open negotiation period hasn't ended, or maybe that this particular situation is not covered by the IDR process, then the party who did not initiate the IDR can object to the IDR process within that 4-day period after the IDR process is initiated. If the parties can't agree on the IDR entity within 6 days after the process was initiated, then HHS will go ahead and appoint its own IDR entity. Now that can be a bit dangerous because the IDR entities have a range for which they can, for the fees that they can charge. If you agree to the IDR entity, then you have some control over that amount, right? You can agree to somebody who's within the range. If you're leaving it up to HHS to go ahead and appoint somebody, then if there's nobody available, then the government can appoint somebody who may be outside that range. So you may not want to let the government go ahead and select that IDR entity. The IDR, as part of the IDR process, the parties have to pay the IDR administrative fee that's is set by HHS, not the IDR entity's service fee, but the IDR administrative fee that the HHS sets. Now, once they begin that IDR process, if the parties agree, negotiate among themselves and come to an agreement on the out-of-network rate that is going to be paid, then they have to let HHS know within 3 days of that agreement so HHS can stop the IDR entity. If that's the case, then the parties will split the administrative fee. If you want to, the parties to the IDR can submit the disputed items or amounts in batches or bundled payment arrangements so that you can address more than one claim at a time for sake of efficiency, and there's some rules concerning how you go ahead and do that. All right, so once you've initiated that IDR process, then within 10 days after the IDR entity is selected, so you get notice from HHS of who the IDR entity is going to be, within 10 days, each party has to submit their proposed out-of-network rate offer. You've got to submit that both in the dollar amount and as a percentage of the QPA. In addition, you'll submit additional information that's requested by the IDR entity. And you're not required to as a provider, but you can if you want. You can submit additional information as appropriate to justify the amount that you're requesting. This is the amount that you hope will offset the QPA or explain why you should get more money than is just set out in that QPA. The factors that I identified would include things like the size of the practice or facility by the number of employees, your practice specialty type, the QPA for the applicable year for the same or similar item or service, the additional any additional information that the party believes is appropriate that you think will support your claim. However, there is certain information you cannot submit, that it's irrelevant. We'll talk about that in just a second. When you submit that rate offer, then both parties have to submit the IDR entity's fee. This is different than the administrative fee. This is the IDR's fee. Both parties submit the whole fee, and then at the back end, the winner will get a refund for the fees that they submitted, but the loser will continue to not receive their money back. So after you've gone ahead and you've submitted that offer, within 30 days after the IDR entity is selected, the IDR issues a written decision selecting one of the offers based on the following criteria. First and most importantly, the QPA for the applicable year for the same or similar item or services. They can also consider any information that was requested by the IDR entity, additional information that was submitted by the parties relating to the provider's training experience, quality, or outcomes, market share, acuity of the patient or complexity of the item or service, the facility's teaching status, the case mix, scope of services, and the like. Prior network agreements between the parties, including efforts to try to negotiate an agreement between the parties, or any additional information that was submitted by the parties, so long as it's not prohibited information. and the information must be credible in order for the IDR entity to rely on that, meaning that it is relevant and that it is supported by actual documents or evidence to support this. Now, in looking at those factors, when that IDR entity weighs all of those factors to determine what the out-of-network rate is going to be, that IDR process is skewed heavily in favor of the QPA. That's the presumptive amount that you're going to get no matter what you claimed. The IDR, the commentary specifically says the IDR entity must select the offer closest to the QPA unless the credible information submitted by the parties clearly demonstrates that the QPA is materially different from the appropriate out-of-network rate. So the way this works is it's baseball arbitration. It's not like you both submit your offers and then the IDR entity splits the baby or comes up with a different rate. No, the IDR entity selects one of the offers that is submitted. They don't come up with their own amount. They select one of the offers that is submitted. And the presumption is that they will select the offer that is closest to the QPA. Now, the IDR entity may select those additional information based on the factors that are submitted, but if they're going to vary from the QPA in their written decision, the regulations specifically say the IDR entity has to clearly demonstrate that the QPA is materially different from the appropriate out-of-network rate. If the IDR entity does not choose the offer closest to the QPA, the IDR entity's written decision must explain how the credible information demonstrates that the appropriate out-of-network rate is materially different from the QPA. So you better have pretty good reasons for justifying your rate if it's not going to be the QPA. Now, there are certain factors that are not relevant, and therefore the IDR entity cannot consider these. It does not matter what your usual and customary charges are. It doesn't matter the amounts that the out-of-network provider or facility would have charged, but for the limit on balance billing. And it doesn't matter the amounts or reimbursement rates payable by a public payer. Those are not relevant to the IDR entity's decision. They can't consider that. There's no use in submitting that information to them. Well, so the IDR entity comes out with its decision, presumably the one that's closest, the offer that's closest to the QPA, unless you can convince them otherwise. What is the effect of that decision? Well, that's binding on the parties absent fraud or intentional misrepresentation of a material fact. There is no judicial review. It's not like you can go to court and appeal it. The party who initiated the IDR may not initiate another IDR involving the same party and the same or similar claims for 90 days. So it kind of gives this cooling down period. So you can't submit a bunch of these in a relevant time period. If you had submitted one during that 90-day period, then the 90-day period to initiate the SDR process is tolled until after that 90-day period ends. Within 30 days of the decision, the loser has to pay the balance that's due the other party. So if you're a provider and you won, then the payer would have to pay the additional amount. If you're the provider and you lost and you owe money back, then you would have to arrange for the repayment back to the payer. The loser remains responsible for the IDR fee, but you've already paid that. You just don't get it back. The winner would get that prepaid fee back refunded to them. If you don't like the IDR entity, sorry, it's not like there's any appeal process out there. It's not, you're stuck with what you got. You can go ahead and complain, petition the government for the denial or revocation of the IDR entity certification for their failure to meet the requirement in the regulations, but it doesn't really address your particular claim. It just, you can express your dissatisfaction with the IDR entity. All right, that is a summary of the rules dealing with the IDR process. Again, I want to emphasize that the IDR process does not apply to all disputes with a payer. It only applies to disputes by an out-of-network provider or facility for those services, emergency services that were provided, or certain services that were provided by an out-of-network facility or an out-of-network provider at an in-network facility. So it's relatively limited in scope. Let's talk about the self-pay patients, because those protections are actually going to be broader in scope. These self-pay patient protections apply to really any healthcare facility and provider. Healthcare facility is defined for purposes of this rule as any institution that's licensed under state law. For example, hospitals, critical access hospitals, perhaps ASCs, RHCs, FQHCs, labs, or imaging centers to the extent they're licensed under state law. In addition, it applies to all healthcare providers who are licensed. That is, any physicians and other providers acting with the scope of their license or certification. So it's extremely broad. But it only applies to uninsured or self-pay patients. That means it applies to persons who do not have benefits under a group health plan, group or individual health insurance coverage, or a federal healthcare program. Or even if that person is insured, if that person does not intend to submit the claim to the payer, then it would also apply to those situations. So for purposes of this discussion today, I'm going to refer to all of these people as self-pay patients. Well, what does this new rule require? Well, it requires convening providers to do certain things. In order to understand the rules, though, we have to define what a convening provider is as compared to a co-provider. A convening provider is different than a co-provider. A convening provider or facility is the provider or facility that is responsible for scheduling the primary item or service. That is, the item or services that is the reason for the initial visit. So if a patient shows up at a hospital, that hospital is the convening provider or facility. It's that convening provider or facility that's generally responsible for obtaining the good faith estimate and otherwise complying with the terms of this rule. In contrast, a co-provider or co-facility is a provider or facility other than the convening provider or facility that furnishes items or services that are customarily provided in conjunction with a primary item or service. So for example, if a patient goes to a hospital to receive care, the hospital is the convening provider or facility. But in the course of that, the services may be provided by independent surgeons or independent anesthesiologists or radiologists, or those independent entities would be co-providers or co-facilities. Well, under the rules, that convening provider or facility must, when that patient shows up or asks about getting services there, they've got to determine, that convening provider has to determine if the individual is a self-pay individual by asking if the patient or proposed patient is covered by a plan, insurance, or federal healthcare program. And if the patient has coverage, ask if the patient wants to have the claim submitted to the payer for the primary item or service, because that'll determine whether or not this person is a self-pay patient. If that patient is a self-pay patient, then that convening facility or provider has to inform the patient that they may obtain a good faith estimate of the expected charges. And they can obtain that estimate either when they schedule the item or services or when that patient requests, or a proposed patient requests, a copy of the good faith estimate. That convening provider or facility has to inform that self-pay patient about their right to obtain the good faith estimate, and they do so by the following. First, you've got to post in your written notice prominently displayed on your website, if you've got a website, in your office, and also on site where scheduling or questions about the cost or items or services occur. So presumably registration or billing or something like that. You would have to have the written notice prominently displayed. In addition to simply having that written notice available, you've also orally got to inform your patients when they're scheduling the item or service, or when the patient asks about the cost of the items or services. So when they ask about the cost, or when you're scheduling, you've got to train your registration or your scheduling people to inform them of the person's right to, if they are a self-pay patient, not insured patients unless they're going to pay for it themselves. But if they're self-paid, then you've got to have your people trained to inform them of their right to obtain that good faith estimate. Now, that notice that you provide must be made available in accessible formats in the language spoken by the patient to comply with the disability rules. The government has posted a copy of the required notice of the right to for the good faith estimate. You're not necessarily required to use this form, but you'd probably want to use this form to protect yourself. It's available again at that website and at the link in the slides. You've got to provide, if that person requests if that self-pay person requests a copy of that good faith notice, or when you're scheduling the patient, then you've got to provide a copy of the good faith estimate. So you have to provide that if the patient requests a good faith estimate, and the regulations specifically define if there's any kind of questions or discussion about the costs, that's deemed to be a request for a good faith estimate. So if you're going to talk to the patient about the cost of the care, then you've got to go ahead and provide them with a copy of the good faith estimate. Or when you schedule the primary item or service, you've got to provide them with a copy of that good faith estimate. The convening facility must, in addition, within 1 business day, ask co-providers or facilities to submit their good faith estimate to the convening provider or facility, so that you could then include those co-providers' good faith estimate in your good faith estimate that you've got to provide to the patient. And you've got to provide that good faith estimate within a certain time set forth in the regulations. Now, going forward, you've got to not only provide your good faith estimate, but get the good faith estimate from co-providers. The government recognizes that may take time to develop a process in order to get that information from the co-providers. So the government, in their commentary, stated that for calendar year 2022, HHS will exercise enforcement discretion in cases where the good faith estimate does not include expected charges from the co-providers or facilities. It doesn't say you don't have to get it, but that seems to be the practical effect, because they're going to exercise their enforcement discretion. I think that means that they're not going to come against you if you don't have that co-provider's information in your good faith efforts. So as a practical matter, unless we get contrary guidance from the government, the convening providers probably don't need to worry about getting the co-provider's good faith estimate until January 1st, 2023. Similarly, co-providers likely don't need to worry about responding to requests for co-payments or the good faith estimates until January 1st, 2023. Now, if you're a convening facility, you've got to provide that good faith estimate within the time required by the regulations. And here's the calendar for that. If the item or service is scheduled at least 3 days in advance, then you've got to provide that good faith estimate not later than 1 business day after the date of scheduling. So if you're scheduling a procedure for a week in advance, then you've got to provide that at least 1 day before. If the item or 1 day after the scheduling. If the item or services is scheduled at least 10 days in advance, you've got to provide that good faith estimate not later than 3 business days after the date of the scheduling. That doesn't give you much time to gather the good faith estimate in order to provide it. So presumably you're going to get your ducks in a row before January 1st, 2022 to come up with a process so that you do have the good faith estimates for kind of your common typical procedures to allow you to meet those deadlines. Now, that's if you're scheduling the patient. If, on the other hand, the patient simply requests a good faith estimate, then but it's not scheduled, then you've got to provide the good faith estimate not later than 3 business days after the date of the request. Except if the patient requested a good faith estimate, but then goes ahead and schedules the services, then you've got to comply with those scheduling requirements. If there's any change to the anticipated charges because circumstances differ, or you need to bring in somebody else or those types of things, then you've got to provide an updated good faith estimate no later than 1 business day before the items or services are scheduled to be rendered. If the patient is going to receive services on a recurring basis, then the rules do allow you to provide a good faith estimate that will apply to those recurring services, so long as certain criteria are satisfied. Specifically, that good faith estimate has to include in clear manner, the scope of the recurring items or services, including their timeframes, frequency, total number of services, etc. The scope of that good faith estimate, you can only do this for recurring services up to 1 year. If it goes beyond 1 year, then you've got to provide a new good faith estimate. Those are the requirements for convening providers. Well, what about if you are a co-provider? Well, under the rules, co-providers, remember the convening provider has to contact the co-provider within 1 business day in order to get the co-provider's estimate. And under the rules, that upon receiving that request from the convening provider or facility, the co-provider has to provide its good faith estimate to the convening provider or facility within 1 business day of the request. If there are changes to the scope of the co-provider's estimate, the co-provider must provide a new good faith estimate to the convening provider or facility. Again, however, as a practical matter, you probably don't need to worry about this until January 2023, at least based on the current guidance. Now, this applies if you're a co-provider. If, on the other hand, the self-pay patient separately schedules or requests a good faith estimate from the co-provider, well, at that time, they then become a convening provider or a convening facility, in which case the co-provider would have to go ahead and comply with the good faith estimate rules as if they were a convening provider. Well, what happens if you have a situation where a provider changes before the actual services are rendered? So maybe you thought that the services were going to be performed by surgeon A, but instead it's going to be by separate surgeon B or a different entity. If the convening providers or facilities or co-providers or facility listed in the good faith estimate change less than 1 business day before the item or service is scheduled to be provided, then that replacement provider has to accept the existing good faith estimate as its own good faith estimate. That is, they're bound by the good faith estimate that was provided by whoever it is they're replacing. If you're a replacement provider, then you're going to want to make sure that you review the any good faith estimate that was provided, so that you can provide your own new good faith estimate if that good faith estimate is inaccurate or doesn't reflect your actual anticipated charges. Well, what does that good faith estimate include? Well, the good faith estimate by a convening provider has to include the following: the patient name and birth date, the itemized list of anticipated items or services provided by the co-provider or facility in conjunction with the primary item or service, the applicable diagnosis, services, and codes with the associated charges associated with that. And when calculating that, you need to make sure that you're applying any discounts or adjustments that would otherwise be available, including if you've got a cash pay discount or charity care, you're supposed to include that in your good faith estimate. The name, NPI, TIN of co-providers or co-facilities in the states and offices where they're expected to be provided, the location where each item or services is going to be provided, the list of items or services that will require separate scheduling, plus an appropriate disclaimer regarding obtaining separate estimates. So the information you've got to provide is pretty specific, and you don't have a whole lot of time to gather this stuff up. But nevertheless, that's what the rule says. In addition to those items concerning the charges, the regulations require your good faith estimate to include a bunch of disclaimers, including that if separate services, that if you do have separate services that are anticipated, and note that the separate that they can obtain a good faith estimate concerning those separate services that will be provided. You have to note that there may be additional items or services recommended as part of a course of the care that must be scheduled or requested, and they're not included in the good faith estimate. That the information in the good faith estimate is an estimate only. The actual items, services, and charges may differ. The patient has a right to initiate the SDR process if the actual charges are substantially in excess of the estimate. Instructions for finding information about the SDR process. You've got to notify them that the SDR process will not adversely affect the quality of their care, and that the good faith estimate is not a contract and does not require the patient to obtain the services or items from any particular provider who's listed in that. So this is part of the stuff that has to go to your good faith in your good faith estimate. Again, the government has provided a form for you. You're not required to use this, but you'll probably want to use this, that contains the elements and the disclaimers that you need. Again, you can access that on the government's website. Now, when it comes to this good faith estimate, you have to take this stuff seriously, because you're going to likely be bound by what's in the good faith estimate. So you're going to want to make sure that that good faith estimate is accurate and it's complete, that it contains all the anticipated charges. Well, that's the good faith estimate that has to be provided by the convening provider. What about co-providers? Well, co-providers also have to provide their good faith estimate to the convening facility, so the convening facility can include those charges in its good faith estimate, but the information is more limited. It includes the information that's up on the screen there, but you probably don't need to worry about that again until January 1st, 2023. Well, how do you provide that good faith estimate? If the patient comes in and requests it, or they schedule the services, then you've got to provide that good faith estimate. How do you do that? Well, the good faith estimate must be in writing and given in a manner that's requested by the patient, either paper or electronically in a form, if you're going to provide it electronically, in a form so that the patient may both save and print the estimate. The patient may request the estimate orally, and you've got to provide it orally if requested, but even then, if they request it orally, you still got to provide it in writing. You must provide that good faith estimate in a manner that's understandable to the patient, not only in easily understood language, but also in a manner that allows the patient to understand and hear or see what that good faith estimate is. To that extent, you've got to comply with the anti-discrimination rules, right? Including you've got to consider vision and hearing, the language limitations, including limited English proficiency, the communication needs of underserved populations, their health literacy and the like. That may require you to involve interpreters, translators, or auxiliary aids in order to make sure that they understand and receive that good faith estimate. That good faith estimate becomes part of the patient's medical record. That means that you've got to maintain it in the same manner as the medical record, and you must keep that good faith estimate for 6 years. And if the patient comes back and wants a copy of that, you've got to be able to provide it to them for 6 years. You want to make sure that you maintain that good faith estimate in case you go through the SDR process or if there's any other dispute over the collections, because that will be relevant to how much you can actually collect from the patient. If there are errors in the good faith estimate, just because you got good faith errors does not mean that you have violated the rules. So presumably you would not be subject to the monetary penalties so long as you act in good faith with reasonable due diligence and you correct the information as soon as possible. In addition, to the extent that you've relied on good faith on information provided you to somebody else, like the co-provider, and if there's an error in that information, again, you're not deemed to be non-compliant so long as you did not know and should not have known of the error and to correct the information as soon as practicable. Now, even though you may not be deemed to be in non-compliance or violate the regulations, that doesn't mean that you can avoid the effects of the SDR. And if your good faith estimate is wrong or is incorrect or doesn't include the information, then you still could be subject to the penalties that are associated with the SDR. With that said, let's talk about the SDR process for self-pay patients. So under this rule, if the total actual billed charges for the listed provider or facility are substantially in excess of the total charges that were listed on the good faith estimate, that is the expected charges, by at least $400, then the patient may initiate a selected dispute resolution process. The total billed charges are defined as the total billed charges for the all primary items or services and all other items or services that were furnished in conjunction with the primary service or item to a self-pay patient, regardless of whether such items or services were actually included in the good faith estimate. So how this works is to determine whether or not the actual charges were substantially in excess of the good faith estimate. That is calculated based on the provider. So let's say you have a good faith estimate. That good faith estimate includes services that were rendered by provider A and provider B. On the good faith estimate, provider A provides services X and Y, provider B provides services Z. The self-pay patient may initiate the SDR if the total charges for X and Y, services X and Y, exceeds A's good faith estimate for such services by $400. So you look at it determined substantially in excess by the particular provider who's rendering the services, not necessarily by each item or service. So you'd calculate all the, or tabulate, include all the services that were rendered by that particular provider to see whether or not it's substantially in excess. Now this is problematic, right? Especially, if it's a minor procedure, maybe a couple of $100, well, $400, it's substantially in excess, it's probably not going to get hit all that often. On the other hand, if it is, if you're doing a procedure or the patient gets an extended course of care and, a $100,000 bill, then it's not too hard to trigger the SDR process because there's a good chance that the bill is going to be over the $400 cap, right? So it depends on kind of the applicability of the SDR may depend upon kind of the overall value of the services that are being rendered. Now, in addition to determining the substantially in excess rule calculation, you have to look at all the items or services that were actually provided, whether or not they were included in the good faith estimate. So for example, if you've got provider Z that included item C in its estimate, but the provider Z bills for items C, D, and E, then the patient may initiate the SDR if the total charges for C, D, and E exceed, oops, I'm sorry, that should be $400. Okay, doesn't matter, the D and E weren't listed in the good faith estimate. To initiate that SDR process, the patient, within 120 days of receiving the bill containing the disputed charges, that patient is, or their authorized representative, they initiate the SDR process by notifying HHS and paying the $25 administrative fee. That notice has to contain certain information. They submit that notice to the government through the portal, the government's portal that they're going to set up, or electronically or on paper. Once that goes into the SDR HHS, then HHS will select the SDR entity. The government's in the process right now of allowing people to apply to become SDR entities, and it's setting up that process. Once the HHS identifies who the SDR entity, it will notify the patient and the provider or facility who that is. The SDR will then review the submission and determine whether or not it's appropriate for SDR, that it did exceed the $400, that it's a self-pay patient, and those types of things. If the patient failed to provide all the information, the SDR entity can give the patient an additional 21 days to provide the information. If the SDR entity concludes the matter is appropriate for SDR, the SDR will request information from the provider and the facility. If the parties settle the dispute while the SDR process is going on, they get together, they discuss it, and they decide to settle it, then they've got to notify the SDR entity within 3 business days, and in that case, they'd split the administrative fee. Now, once you as a provider get notice of that SDR process that is pending, essentially at that point, you need to stop your collection activities. The regulations state while the SDR process is pending, the provider or facility must not move the disputed bill to collections or threaten to do so. If the bill was moved to collections, you've got to cease collection efforts. You've got to suspend the accrual of late fees on the unpaid bill amounts, and you cannot take or threaten any retribution against the patient to obtain resolution of the dispute. So you kind of have to suspend everything while you're going through the SDR process. Now, once you as a provider get notice of that SDR entity, you've got to submit to the SDR entity within 10 days the information required for them to make the SDR determination. Specifically, you've got to provide a copy of the good faith estimate relevant to the disputed bill, a copy of the bill charges that are subject to dispute, and if available, any documentation showing that the difference between the bill charge and the good faith estimate reflects the following. This is the relevant standard. So if you want to know whether or not you're going to win on the SDR process, this is the standard that you have to establish. You have to establish that the amount that was actually billed reflects the cost of medically necessary items or services, and there were unforeseen circumstances that could not have reasonably been anticipated by the provider or facility when the good faith estimate was provided. That's what you've got to establish if you're going to vary from the good faith estimate. Within 30 days of receiving the provider and facility information, that 10-day period, the SDR entity must make the determination of the amount that's owed by the patient. Again, the basis for the decision, the test, is whether or not the amount actually billed represents the cost of medically necessary items or services, and the difference with the good faith estimate is based on an unforeseen circumstance that could not have reasonably been anticipated by the provider or facility when the good faith estimate was provided. In most cases, that's going to be a pretty hard standard to satisfy. And therefore, you've got to really make sure that your good faith effort, your good faith estimate, to the extent you can, is accurate and complete. So in making the determination, this is how it comes out. The SDR entity has to decide this. The rules tell them this is how you decide SDR entity. If the bill charge was listed on the good faith estimate, so you included it in the good faith estimate, If the billed charge was less than or equal to the expected charge, then the patient will pay the billed charge. If the billed charge is greater than the expected charge and the provider fails to prove that it reflects medical necessary services or that it was unforeseeable, then the patient only pays the expected charge from the estimate. So if you lose, the patient only has to pay the expected charge from the estimate. On the other hand, if you win, if the billed charge is greater than the expected charge and the provider proves that the additional items provided were medically necessary and were the result of unforeseen circumstances that caused the variation from the good faith estimate, then the patient has to pay the lesser of the following. They don't automatically get the billed charges. Instead, they get lesser of the following. The patient would only have to pay either the lesser of the billed charge or the median rate of the insurer if the expected charge is less than the median rate, unless the expected charge is greater than the median rate. Okay, so they have to pay the lesser of the billed charge or the expected charge if the expected charge is greater than the median rate paid by a payer for the same or similar service by the same or similar provider in the geographic areas listed in the independent database, or if the median rate, that median rate that was just described, is less than the expected charge, then they would pay the median rate. So there you go. That's kind of the way that that process works to determine what the self-pay patient is going to have to pay. On the other hand, if the billed charge is not listed on the good faith estimate, then if the provider failed to provide prove the medical necessity and the unforeseeability, the patient has to pay zero for that additional item or service because it wasn't within the good faith estimate. On the other hand, if the provider proves that that additional item that wasn't listed is medically necessary and its inclusion, the failure to include was not reasonably foreseeable, then the patient pays the lesser of the billed charge or the median rate paid by a payer for the same or similar service by the same or similar provider in the geographic area as listed in an independent database that the government is developing. So, depending on the decision, the patient is going to have to pay one of the following: either the total expected charges from the good faith estimate minus the $25 administrative fee. That's taken out of the money that would go to you if they win. They may have to pay the billed charge if you win, or if you win but the median charge is less than the billed charge, they're just going to have to pay the median amount of the same or similar services by a same or similar provider in the geographic area. To calculate the final payment amount, the SDR entity adds together the amounts to be paid for all items or services as determined by the SDR entity. If the SDR amount is less than the billed charges, the SDR entity subtracts the administrative fee from the amounts to be paid, and that's the amount that the provider is supposed to pay. In that situation, the provider or facility effectively pays the administrative fee because it's deducted from the amount that the provider can otherwise obtain. The SDR entity then informs the parties through the federal IDR portal, email, or by paper mail. That SDR determination is binding on the parties absent fraud. Now, just because you get that SDR determination, the effect of this is that, okay, you're bound by it, you can't go after more, but you still have to go after the patient, right? That SDR determination doesn't necessarily require the patient to pay it, or there's nothing to force the patient to pay it. So you'd still have to collect against the patient. As a practical matter, it may be that you're still going to negotiate with the patient to get paid. However you do that, either through negotiating a lower amount, financial assistance, or whatever. The government has issued a new website for consumers that advise them of their rights under the no surprise billing rules, that they can access that. In addition, remember that for all of you who have state laws that may apply, you need to make sure that you are coordinating these new rules with those state laws, including the net effective is basically if the state law provides greater protection to the patient than the no surprise billing rule does, then you got to comply with the state law. To the extent that the state law is less protective, then you got to comply with the no surprise billing rules. These no surprise billing rules were issued as interim final rules, so they're still collecting comments. The government asked for a bunch of comments when they issued the rule. The comment period for the rules close on December 6th. So if you really hate these new rules, you've got until December 6th to go ahead and submit your comments to the government. That is a brief overview. Let's talk briefly about, okay, what's the net effect of that? What do we have to do by January 1st, 2022? Well, this is kind of my quick checklist. You should confirm and coordinate state law requirements to make sure you understand what you have to do. You need to determine if you are an out-of-network provider or out-of-network facility that renders emergency services or non-emergency services at an in-network facility. If you are, that generally determines your Part 1 compliance, right? If you're never one of those providers, then you really don't have to worry about Part 1 or dealing with the IDR process. On the other hand, if you are an out-of-network provider or facility that renders those emergency services, or you're an out-of-network provider that renders the services at one of those identified facilities, then you may want to go ahead and implement the policies that are required by Part 1 in order to ensure that you can collect the maximum that you can under the out-of-network rate. Determine if you are going to attempt to obtain advance notice and consent from patients for out-of-network services in those emergency or non-emergency services identified above. That will be really hard to do. As we talked about last time, there is a process for you to do it, but I just think it's going to be really rare when you're going to be able to get that, because, you know, how often are you going to have patients, after you give them notice and seek their consent, say, oh yeah, that's fine, I'll go ahead and pay you more than I'm otherwise required under the law. But if you're going to try it, then make sure that you got that notice and consent process set up. Determine if and when you are going to initiate the IDR process for disputes with payers, because it can take up time and sometimes it may not be worth it. So you may want to set parameters and determine, you know, to what extent you're actually going to initiate that process. Determine if and when you're going to respond to the SDR for disputes with patients. Again, these are self-pay patients, which some of us refer to as no-pay patients. It may be that it's not worth it to you to go through that SDR process, and you may have a policy that if the patient objects, you're not going to make a big deal about it, and you're just going to go ahead and accept your good faith estimate. It's just something you may want to consider as a policy, because that will determine how, you know, your compliance steps later on. You are going to have to obtain or create the required forms or documents. If you're going to bill for out-of-network services, then you need to make sure that you, if you're going to go through the notice and consent process, that you have those notice and consents set up and ready to go. If you're going to rely on the facility in order to provide the relevant notice to patients, then you need to make sure you have an agreement with those facilities, like we talked about last time. If you're going to participate in the IDR disputes with payers in those situations, then you're going to want to develop your notice to initiate the 30-day open negotiation period so that you can provide that to the payers. You're going to want to collect your notice to initiate the IDR. You're going to want to develop the forms that you need in order to submit the rate offer, because that will normally include some additional information if you want to rely on it, including identifying the additional supporting criteria you want to include in your rate offer, because you're not going to have a whole lot of time and you want to make sure you include that additional information. Again, those notices have been developed through forms from the government, so you can access those on the website that I referenced. When it comes to the good faith estimates, you're going to want to develop your good faith estimate form, right? Because you haven't got much time in order to give that to the patient. So you'll presumably have a form that developed with the appropriate disclaimers so that you can prepare that and give it to the patients, at least a template. Like I said, because of the time frame, you might want to have a process so that you have a good faith estimate already generated for certain types of routine procedures that you can use. You need to have the forms that you need for the disputes if you are going to go through the SDR process and disputes with self-pay patients, including a form in order to respond to the SDR entity that provides the items that you need, including your good faith estimates, your bills, and additional supporting documents that you might need. You need to post the notices, including the regulations require you to post the notice of a right regarding balance billing. That generally only applies if you do have the balance billing situation, but that'll apply to most of your facilities, most of you hospitals for certain, and also a lot of you other providers who provide out-of-network services at facilities. In addition, you're going to have to notice, all of you are going to have to notice that the right of self-pay patients to receive that good faith estimate. You need to publish that notice on your website, a sign in prominent locations in your office or facilities. You've got to also have it available at the locations where billing questions are asked or discussed. And remember, you have to comply with the applicable language and accessibility requirements, meaning that It has to be written in a form that's easily understandable. Presumably, you'll use the HHS forms. You're going to need to translate it into relevant languages consistent with the anti-discrimination laws. You may have to use interpreters or auxiliary aids to make sure that that's communicated effectively. Next, you're going to want to make sure that you come up with a process for calendaring appropriate deadlines, including the IDR process, so that you don't miss the deadlines. Those are pretty much summarized here, especially the ones in red. Remember, you've only got a certain period of time to initiate that IDR process if you want to negotiate or get a different rate from that out-of-network provider. So make sure that you've got a process set place with deadlines and that you train your people concerning those deadlines. To those extent, you're going to, or to that end, you're going to want to make sure you develop and train your staff regarding the internal self-pay patient process. This again applies to pretty much all providers and facilities. So that process would have to cover the things like determining if the patient self-pay, what questions do you ask? Maybe you have a little template for them. You advise the patient of their right to obtain a good faith estimate. You've got to generate your good faith estimate. Again, you'll probably want to develop templates or a database with the relevant expenses so you can generate that. That good faith estimate has to contain the required elements. You need to obtain that estimate from co-providers or facilities. Probably don't need to worry about this for the next year, but effective January 2023, you'll need to do that. You need to provide those estimates to the patients in a timely manner, consistent with those deadlines that I talked about earlier. You need to update the estimates as appropriate. Otherwise, you're going to be bound by any out-of-date estimates. If you are a replacement provider, you're going to want to review and update your estimates. Otherwise, you're going to be bound by the estimate that was given the patient. And you've got to maintain a copy of that good faith estimate in the patient's medical record. You're going to want to calendar the process for those SDR deadlines. Again, similar to the IDR, the key here for you guys, for providers, is once you get that notice of the SDR, you need to stop collection efforts and you need to respond to the SDR within 10 days of the notice by providing the relevant information. You're going to want to educate your staff concerning all of these requirements, and think about the staff that you need to educate. It's probably going to be certainly your payer contracting persons, your medical staff office, your patient intake and scheduling, billing and collections personnel, compliance personnel, website design, and perhaps others. After January 1st, 2022, stay tuned. Actually, before, stay tuned too. Watch for additional guidance that may come out from HHS, including additional HHS forms. The final rules that may come out, it's possible that they may change because these rules, quite frankly, I think are pretty draconian, and there's getting a lot of pushback from the healthcare providers and others. So it's possible that they may change. So watch for those changes, but don't hold your breath, right? Right now, you've got a January 1st deadline. You need to move forward. Watch for additional regulations to implement other portions of the No Surprises Act. Right now, we're only required to get that good faith estimate to self-pay patients, but the Act actually requires a similar good faith estimate to insured patients, but the government has postponed that. We don't have regulations on that right now, but that may come down the pipe. As far as additional resources, again, the government has that website where a lot of its forms and guidance is provided. You can go to that. If you haven't done that, you need to do that and see what's available there. It will take you to Department of Labor, additional Department of Labor site that has additional forms on it, including the notice of open negotiation period, the notice of the IDR initiation, the notice of the IDR entity selection, the notice of an agreement on an out-of-network rate, and the notice of an offer. The government's also got, for Part 2, a separate website that has some of the notices and forms that we talked about. In addition, the government has a website that has the notices that we did not talk about today because they're dealing with Part 1. At the time that I did the Part 1 program, I did not have those available. But this website gives you the notice concerning the patient protections against surprise billing that you have to post. In addition, the notice and consent documents, if and to the extent you want to use those in dealing with and seek balance billing from patients for certain types of services. There are copies of those notices, and that is it. Our prior webinar, as well as other webinars, are available on our website for free if you want to go back in there and listen. This program will also be uploaded and available at that website. We also have a lot of publications that are available for you if there's anything you need on these compliance related issues, that's a good resource for you. Any questions about this? Feel free to shoot me an email or shoot me a chat. I will do my best to respond, but I'll tell you, it's been pretty hectic lately with COVID mandates or vaccine mandates and everything else that's been going on, but I'll try to respond as I can. Otherwise, thank you very much. Good luck with this. Remember that this will require a change in how you do business. It is limited to only certain situations involving out-of-network payers and self-pay patients. It's not going to apply to probably the vast majority of your patients, but for those that it does apply to, then you're going to want to make sure that you're up to speed and you move forward with compliance. Thanks, take care, and good luck as you move forward.